Good afternoon. My name is Ronaldo Hilton. I'm the chairperson designee for the New York City Law Court. And I want to welcome everyone to our April 20th public meeting. So we first turn to a vote on the minutes from the March 16th public meeting. Are there any corrections or comments to these minutes? So do we have a motion from the board to accept the minutes? Mr. Coleman? Second, Mr. Robinson. Mr. Rivera?
Mr. Cover.
Yes.
Mr. Backward.
Yes.
Mr. Rouge.
Yes.
Mr. Hernandez.
Yes.
Mr. Delaney.
Yes.
Ms. Sheldon. Abstain. Chairperson Hilton.
Yes.
6 in favor, 1 abstaining, and 2 absent.
Thank you. The executive director, Ms. Elaine Walsh, will now give her report.
So the first thing on the agenda is to welcome our new attorney, Cynthia Liddell, who's sitting at the end there, to our staff. She's going to be focusing her going on enforcement matters, but you will be hearing from her at future meetings. In terms of rulemaking, we are still plowing through, and we hope to be bringing you Chapter 1 next month, and we'll get you the draft as far as possible in advance, more than the weekend before the meeting, so that you can look through it. It's not terribly long, 16 pages, so with a lot of white space. So with a lot of white space in rules, makes it easier to read. So the board had asked for monthly revenue reports. So again, this is unofficial. The unofficial monthly revenue collected in March was $55,240. In terms of the upcoming deadline for filing registrations and coverage applications, if anybody doesn't know, the deadline is June 15, 2017. So if you are thinking of filing for coverage or filing registration, you should do it you must do it prior to that date. As the board requested last month, we resent emails to city council members, board, community boards, and borough presidents. We also send out hard copies. There is a workshop scheduled with the law court staff and the Department of Cultural Affairs for April 28, 2017 at 4:30 in the afternoon down the block at Surrogates Court, 31 Chambers Street on the 2nd floor. If anybody's interested in attending that, we will sort of go through the issues of coverage, how to file for coverage. So if you're interested and you want more information, that's a good place to get it. Finally, the board had asked us to do some maps for where the loft properties are located by Assembly District, State Senate District, and Council District. So we did these maps. They are a work in progress. The idea is to make them interactive and put them on the website. But for now, here's what we have. So here's the Council Districts, and this was done all on one page. So you can see very crowded here in Lower Manhattan, parts of Brooklyn, a couple of outliers here. The Long Island City property, we have our little property in the Bronx, and if you scroll down, if I can scroll down, here's our one little Staten Island property that's under law court jurisdiction. The dots each represent a property that's currently under our jurisdiction. I'll get to the next map. It's not a program I've ever used, so. Okay, so here is the map by assembly districts. So you can see the borders are slightly different. And we also have Staten Island there. And then we broke it down for city council. Let's figure this out. We broke it down by borough to see what that would look like. And I think that works a little better. So this one is, there should be multiple pages. I'm sorry, it's just difficult to turn around. Oh yeah, here. So the Senate one has Bronx. So you can see one property in the Bronx. There's Brooklyn. So although the Manhattan properties are on here, really this map is focusing on Brooklyn. You can see this property all the way out here at the Queens border. Here's Manhattan. So again, even though the Brooklyn properties are on here, the focus in Manhattan is downtown. And Queens, it's really just one over there. Oh, two more over here. Ridgewood, in that area, one right on the border. And then our one Staten property. So that's what they look like for now. We'll continue working on them, and hopefully you'll be able to click on the property and go in and get more information about the buildings. But we have started working on it, so I want to report back to you.
The idea is to get it more interactive
Yeah.
and on our website.
On the website, yeah.
Will you just be distributing these to the board members?
I'll be more than happy to send it to you.
Yes.
Sure. We also have they're also, the information is based on a spreadsheet, but the spreadsheet has to be updated, so we're going to post that as well.
Yeah, the spreadsheet is woefully out of date.
Yes, yeah, we have a new one in a, I think, a better format. But we have information that we need to fill in, like D numbers and big numbers and things like that. So we're hopefully going to have summer intern, and that's one of the projects.
Is it, I think this is terrific, and I really, I just have ability. Is there any way that you make a determination of when these buildings, the dates of them?
When they first came in under
Yeah,
our
when they first
jurisdiction.
came into our jurisdiction.
You can't from the maps, but one of the fields on the spreadsheet is the date that the IMD number was assigned. So that would be when it came under the law enforcement jurisdiction.
All right, I'm just thinking about making a cross-reference, but okay.
I don't know how you get, I guess we could consider if you're going to click and there's going to be a dialog box that opens up. Of
Yeah,
that
yeah.
dialog box is probably the wrong term, so I'm not computer savvy, so don't get on my case about that. But if a box opens up and you want that information, the board wants that information in there, we can make sure that it's in there. So do you think that would be helpful?
Is that something that you want in there? The date that the building went?
Well, I mean, it would be nice to,
Yes, so you want
it
it.
would be nice to know for a whole bunch of other reasons.
But we could get it.
Yeah, I mean,
What I'd like to know is the old, you can see by our color code, what's the old, looking at the old one and the new here.
Okay, so 281 versus 281 versus 281.4 versus 281.5.
we still have in the original 281, we still have I haven't seen a number of how many laws are still in the process.
We can try and get you that information, but I don't have that at my fingertips.
We were down to like 300 before
It was
this.
down and said, yeah, no, see, this is amazing. It started at 714, 2081, and here we are, and we still have 300 buildings in the original.
But there are buildings that have come and gone, so, it seems that the figures always kind of hover around 300, and so some come in and some go. But yes, there is a big difference between the 281 ones and the 281 fives. So we can get you those figures, but I don't have them with me now.
That's a report that former executive director Alexander used to issue pretty regularly, so there's a template for that, and it would be good to get that again.
Okay. That's it.
Thank you, Ms. Bowles. So we turn next to the...
I'm sorry, I didn't know if that was the end of the slideshow or...
Do you need it, or-
No. I just had a question. You mentioned that you hope to circulate the first section of the rules next month. Have you given any thought to how you plan to proceed with regard to, are we going to publish those and discuss those?
We can't publish them until the board approves them,
Right,
And yes,
of course.
you will be seeing them and discussing them, and that is in public session.
That's,
Is that the question?
no, not exactly.
Okay.
The question is, will you then seek to move forward on section 1 of the rules?
With the CAPA process?
Yes.
No.
So you plan to, so they'll just be kind of in the discussion phase for a longer period of time as other rules?
Well, my hope, and it could be a pipe dream, is that we would finish chapter 1 next week and then do chapter 2 the next month. Now, chapter 2 might take 2 months because it's much longer and there's probably more to discuss. And then I would like to do the CAPA process all at once. I think passing rules piecemeal is very dangerous because you can have cross references that don't match. Remember, we're repealing everything and we're going to have new numbers. So you really can't do it piecemeal.
And the draft of the first section, when you distribute it to the board members,
Right.
that would just be for discussion.
Yes, and then whatever changes you have, we would make the changes, and once it's finalized, and once chapter 2 is finalized, then we'll start the CAPA process. And basically, that's going to be the law department and the mayor's office of operations, and that's going to take probably at least 2 months, maybe longer.
And there'll be a hearing, of course.
Huh?
There'll be a public hearing.
Yeah.
Oh, yes.
Yeah.
The capital.
Yes, yes.
And those discussions will be held in the public meeting.
Of course, yes. Rulemaking was done in public.
Just so you know, before you even go to capital, as Renee mentioned, the board actually approves the changes.
Oh, yeah.
And we won't schedule a public hearing. I mean, the mayor's office of operations and the law department will have changes because they always do. And we submit those changes to the board, the rules as changed, to the board before we do the public hearing.
And do you envision sharing the proposed rules, changes, modifications, repeal and replacement? That sounds awful, doesn't it? With the public prior to the start of the capital process?
No. The public has a very defined role in terms of when they can comment, and that is at the public hearing.
But we'll discuss the changes in public,
Yes.
so the public may hear from them.
Yes.
Yes, absolutely. And if the board feels that the public discussion or the public comments are valid and wants to make the changes to whatever comments the public made, it's still up to the board to make those changes or to go forward with the rule, right?
Yes.
So after the public hearing, so they can be modified after the public hearing.
And my interest is in getting the proposed changes into the public's realm as quickly as possible, to give them as long as possible.
I understand, no, there'll be no longer period of time for the public to comment more than one time from the publishing of the rule. The initial publication of the rule, 35 days, so it can't be longer or shorter.
The problem is,
Let-
I understand where you're going with this. The problem is, you get so much input that you can't move forward. So I think that the reason that CAPA is structured that way is to make sure that the process could be completed, because otherwise you could have 6 months worth of meetings on rules that the law department hasn't even seen yet. So I think that's not really fair to anybody, including the public. So,
We wouldn't want that.
well,
I mean, frankly, I dislike the approach in the sense that when, say, under Euler proceedings, there's a limited clock for comment and action by the various bodies. But frequently, what the proposal is has been debated in public for a much longer period of time.
right.
My My concern here is that, given the complexity of the rules and the detail, I would like to make sure that the public, both owners and tenants, as well as the attorneys that work for both owners and tenants, have as much time as possible to study the rules.
They're welcome to foil anything that's a public record, including the document that will be given to you. But as I said, since it's going to change, I'm not sure that it's going to work.
Okay.
I'm sorry for the interruption. So, are there any extra chairs? Okay, here's one. Right there. Okay, thank you. Just give me a second to get this rearranged. Mr. Delaney, is that all? Do you have anything else?
Question. No, that's all.
Yeah.
Thank you. So we next turn to the reconsideration calendar. There are two reconsideration cases, and the first one. The first case on our first reconsideration case on the calendar was Kent Avenue Holding LLC, and that case is being tabled for this month, so there will be no vote on that case. The second case involves Gregory Levitt at 103-11 North 10th Street in Brooklyn, docket number R0351. Mr. Alson.
Thank you. This is the third time this matter has come before the board. Gregory Levitt, occupant of Unit 2B and former occupant of Unit 3C in the building located at 103 North 10th Street in Brooklyn, seeks reconsideration of Law Court Order 4563, which rejected the party's second proposed stipulation of settlement. The first time this matter was before the board found that the parties' agreement violated public policy because Mr. Levitt would relinquish his claims for Article 7C coverage while continuing to residentially occupy a unit in the building that does not have a residential certificate of occupancy. After remand, on May 1st, 2016, tenant and owner entered into the current stipulation. Instead of moving to Unit 3B from 3C, as they agreed in the first agreement, tenant now agreed to move from Unit 3C to Unit 2B and withdraw his claim with prejudice. In Order 4563, the law court rejected this stipulation for exactly the same public policy reason. The stipulation permits tenant to reside in a space that lacks a residential certificate of occupancy and is not subject to Article 7C protection. On December 1st, 2016, the staff registered the building. On January 27, 2017, owner filed an initial registration application which added an additional IMD unit and indicated that the unit designations within the building had changed. Owner did not register Unit 2B, currently occupied by Mr. Levitt, or any unit that either of the parties' stipulations permits Mr. Levitt to residentially occupy. Tenant's argument that it is undisputed that there was a certificate of occupancy on May 1st, 2016, the date of the stipulation, is incorrect. The argument mischaracterizes the building's temporary certificate of occupancy as if it were a final residential certificate of occupancy. A temporary certificate of occupancy is not a certificate of occupancy. A Section 301 of the MDL requires a certificate of occupancy for residential occupancy in a multiple dwelling. And MDL Section 281, Section 3 requires that non-residential space in a building as of the effective date of the loft law shall be offered for residential use only after obtaining a residential certificate of occupancy for such space, even if a portion of the building is an IMD. Tenants' residential occupancy of non-IMD space violates the loft law and other provisions of the MDL. The staff recommends that any agreement that purports to permit residential use in a unit that does not have a residential certificate of occupancy or is not an inter-multiple dwelling is against public policy and should be rejected by the law board. Accordingly, staff recommends that the application be denied.
Thank you, Mr. Asman. Does anyone have any comments on this? Yes?
Yeah, I'm going to vote in favor of denying reconsideration, but I just want to reiterate my concern, as we'll see in the case shortly, where the board has a tendency to look at stipulations and sometimes say, we'll accept the withdrawal without any, notwithstanding the contents of the rest of the stipulation. Here, we took issue with the stipulation as a matter of public policy, and I have expressed this sentiment before, both in the public session and in the new private sessions that we had, that I think we either read stipulations and adhere to all of it or ignore it. So in this case, I'm going to vote in favor of denying reconsideration, but I think Mr. Levitt's trapped. The landlord should fix up the unit and let him stay in where he was.
Does anyone else have any comments on it? Okay, is there a motion then to accept this case? Thank you. Mr. Shelley? Any second? And Mr. Roach? Ms. Rivera, please.
Mr. Garber.
Yes.
Mr. Barrett.
Yes.
Mr. Roach.
Yes.
Mr. Hernandez.
Yes.
Mr. Delaney.
Yes.
Mr. Shelton.
Yes.
Chairperson Henson.
Yes.
7 in favor, 2 absent.
Thank you, Mr. Rivera. There are 9 summon cases. We are going to separate out one of those cases for separate voting. So I'm going to read the first 8 cases that we'll vote on first. The first 8 cases will be voted on as a group. Earlier when the board met in private session, there's going to be 2 ministerial changes to 2 of these orders, and I will state on the record what those 2 changes are when I get to those cases. So that case is the following 9 cases are going to be voted on as a group. They are 57 J Street LLC at 57 J Street, Brooklyn, docket number LC 0165. 57 J Street LLC at 57 J Street, Brooklyn, docket number LC 0167. You have Alpha Brown Bawa and Eleanor Mar Edison at 181 Christie Street in Manhattan, docket number P0-0036 and TR1309. In the case of Lila Wilson at 243 Grand Street in Brooklyn, docket number P00044, there is a change to that order, and the last sentence, the second to last sentence would read, in a letter dated January 27, 2017, tenant's attorney withdrew the application with prejudice. The word protected is being stricken from that, so that's the only change there. The next case is Matthew Koch at 1099 Flushing Avenue in Brooklyn, docket number TA0225. Then the next case, Eric Richard Buchel, Kathleen Ann Tucker, Therese Monica Paolini, and Sean Monahan. Docket number, this is 324 Canal Street, Manhattan. Docket number TR1286. The next case is Deborah Kramer, 35 Claver Place in Brooklyn, TR1316. Finally, the case Lila Wilson, 243 Grand Street, Brooklyn, docket number TR1317. There is a ministerial change to insert the word occupant in the second to last sentence on the order to read, in the letter dated January 27, 2017, tenant's attorney withdrew the protected occupant application with prejudice. So the word occupant is inserted after protected. That word. I switched it. Oh, I'm sorry. Sorry. Let me just correct for the record. In this order, the second to last sentence is read, in a letter dated January 27, 2017, tenant's attorney withdrew the application with prejudice. The word protected is being stricken. Thank you. Do we have a motion? Does anyone have any comments on this case? These cases? No? So is there a motion to accept these cases? Thank you, Mr. Barnes. Is there a second? Mr. Robinson, second, and Ms. Rivera, please pull the board members.
Mr. Carver.
Yes.
Mr. Barber.
Yes.
Mr. Bush.
Yes.
Mr. Hernandez.
Yes.
Mr. Delaney.
Yes.
Ms. Shelton.
Yes.
Chairperson Henson.
Yes.
7 in favor, 2 absent.
Thank you. So the next case, the case that we're going to go back to is the case involving Aaron Steinberg at 397 Bridge Street in Brooklyn, and docket number TR1312. Does anyone have any comments on this case?
Yes, I'm going to vote no on this case, even though it's a summary county case. Here's an instance where Mr. Aaron Steinberg, 397 Bridge Street, with his attorney, filed an application seeking coverage of the 8th floor at 397 Bridge Street. And in the application said that there were a total of 9 residential units. Mr. Steinberg entered into a stipulation which the law court neither accepts nor rejects the remaining terms thereof, which afforded Mr. Steinberg a so-called $160,000 surrender payment and the waiver of rent to the tune of $31,000. So that's about $200,000. This case is now withdrawn. There is no coverage case before the law court because Mr. Steinberg accepted a surrender payment. I'm told in the private session that there are other applications that relate to this building, but they have not come through as yet. And my position is once somebody applies for coverage and says that there are 4 or 6 or however many residential units in an IMD building, that the individual should not be able to withdraw that case in a way that takes the law court's scrutiny away from it. That, in other words, the landlord, 397 Bridge LLC, should not be able to buy people off and try to evade the law firm. That's I'm going to vote no, and I think the board should have a mechanism to keep a case like this active and convert it into a board-initiated proceeding, which was also discussed in private.
Are there any other comments in public on this?
Oh, I'm sorry, and I forgot to add one thing. Forgive me. The stipulation that we either accept or reject allowed Mr. Steinberg to live there from October 31st, when the stipulation was signed, until conveniently April 3rd, a few weeks before this meeting. So in the other case of Mr. Levitt, where we won't let him live in a space that's not covered, we allowed Mr. Steinberg to live there for 7 or 8 months. So that doesn't make sense to me.
Does anyone have any other comments? Thank you, Mr. Lane. So if no one has any comments, do I have a motion to accept the case? Thank you, Ms. Shelton. Do we have a second? Mr. Carver. Mrs. Rivera, please poll the board members.
Mr. Carver?
Yes.
Mr. Roberts?
No.
Mr. Roach?
No.
Mr. Menendez?
Yes.
Mr. DeLeo?
No.
Ms. Shelton?
Yes.
Chairperson Hudson?
Yes.
Three in favor, 3 against, 2 absent.
You said you have 3 in favor and 3 absent?
4 in favor, right?
4 in favor.
Could you just repeat that?
4 in favor, 3 against, 2 absent.
Motion passed.
Well, we have a problem here. The problem is to be 5, even though there are 2 absences. So this motion doesn't carry.
It doesn't carry.
Yes, doesn't carry.
It does not.
We went around on this a few years ago. The court counsel said it's got to be 5 of the authorized.
It's a state law.
Right?
It's a state law unless there's an exception.
So this case will have to be revisited. This did not carry. We now turn to the master calendar cases. There are 3 cases. The first one is the estate of Minda Bigman by the administratrix Carla Bigman at 595 Broadway, Manhattan, docket number LF0132. Ms. Paulson will present this case.
This is an application that seeks possession of a unit and evaluation for purposes of evaluation of fixtures. The original protected occupant, Minda Bigman, died in 1997. Her death created 2 lines of court cases, both law board and then into court. One line of cases was whether or not the sister of Minda, who is also the administratrix of the estate, Charlotte, could succeed Minda as a tenant with rights under the law for the apartment, and the court clearly said no, she had no prior connection to the apartment, so she couldn't have the apartment. The landlord then filed an abandonment petition with the law board, seeking to have the unit declared abandoned, and as part of that petition, Charlotte, as administratrix of the estate, asked that the fixtures be sold and that the estate get the money for those fixtures. The law board denied that request, but granted the abandonment application, and that issue as to whether or not the estate was entitled to any money because of the fixtures also was litigated all the way up to the Court of Appeals, and the Court of Appeals said yes, the estate should be able to get fixtures. Subsequent to that, this application was filed, and the application states that Ms. Bigman, as the administratrix, would like to take over the apartment and then sell the fixtures to herself as the incoming tenant. Clearly, she's not entitled to do that because the court said she has no rights to the apartment, but the court also ordered the loft board to sell the fixtures. The problem is that the fixtures are long gone. So what do? Fortunately, during the abandonment proceedings, several documents were filed about the valuation of the fixtures. There was one that was filed by the landlord, and his architect valued the fixtures at $9,762.50, accounting for the cost of the materials, depreciation of some of the materials, and some of the fixtures. The state's architect filed a document asking for somewhere around $44,000 for the fixtures. Some of the things on that list were things that had been installed after the protected occupant had died, so clearly the estate wasn't entitled to any money for that. But we also had a transcript of Minda Bickman testifying at a hearing about rents and loft rents. And at that hearing, she said she had spent about $8,000 on the fixtures and expected to spend at least another $1,000. That would bring it to $9,000. So the loft board is valuing the fixtures at $9,762.50.
Thank you, Ms. Paulson. Does anyone have any comments on this case? Is there a motion then to accept this case? Thank you, Ms. Narlow. A second? Mr. Robinson. Ms. Rivera, could you please call the board member?
Mr. Carver.
Yes.
Mr. Robert.
Yes.
Mr. Ruth.
Yes.
Mr. Hernandez.
Yes.
Mr. Davina.
Yes.
Ms. Shelton.
Yes.
Chairperson Hudson.
Yes.
7 in favor, 2 absent.
The next master case is Maria Nazor and Peter Nickel at 544 West 27th Street in Manhattan. Docket number TR1184, and Ms. Paulson again will present this case.
This is an application seeking coverage and protected occupant status for two people, Maria Nazar and Peter Mickle. It was a 7-day trial at the Office of Administrative Trials and Hearings. The ALJ recommended that the loft board deny coverage because the tenants failed to demonstrate that the building was occupied as a residence for two families living independently from one another for the 12 consecutive months in 2008 and 2009, which is the multiple dwelling law 2815 window period. The first thing to note is that this building is located in West Chelsea district, where you only need 2 occupants during the window period. Despite that, the tenants allege that there were in fact 3 units that were occupied during the window period, 2 on the 4th floor, 1 by Ms. Nazar, 1 by Mr. Mickle, and then 1 on the 5th floor, which was allegedly occupied by the principal of the owner of the building. There were extensive court proceedings prior to the filing of the coverage application. Both sides argued that findings in the court proceedings should apply in the loft board proceedings. Really, for various reasons that are stated in the order, we find that that isn't true, with the exception of one finding, which was that the owner of the property did in fact have an apartment in 5N, but he didn't actually reside there. He actually resided in Tenafly, New Jersey, so that means that his occupancy doesn't count, or his alleged occupancy doesn't count. Then we turn to the question of Ms. Nazar and Mr. Mickle and whether or not the two of them actually lived there. And separately, during the window period, there's no question, I think, that Ms. Nazar lived there, so that leaves Mr. Mickle. I would note that the parties are married, although they claim they have always resided separately in the 2 different units. But in fact, there was a tremendous amount of proof that was offered to show that after the parties separated, Mr. Mickle actually took a 1-bedroom apartment on West 14th Street, and that is where he was residing during the window period. The person he was leasing that 1-bedroom from was subsequently evicted, and he may have moved back to the building, but the record is fairly clear that during the window period he was not residing at West 27th Street. So we are recommending to the board that we find that the tenants failed to prove that 2 families lived independently in this building during the window period, and it's not an IMD.
Thank you, Mr. Walson. Does anyone have any comments?
I'm going to vote no in this case. I'm not persuaded as to the level of residential use by the landlord. And so, in my view, I think there is an argument that this is a good cut.
Does anyone else have a comment? No? So then, can I have a motion then to accept this case? Mr. Carver and Ms. Shaw, in that order. Can you please call the board?
Mr. Carver?
Yes.
Mr. Barbares?
Yes.
Mr. Roach?
Yes.
Mr. Hernandez?
Yes.
Mr. Daniel?
No.
Ms. Shelton?
Yes.
Chairperson Hudson?
Yes.
6 in favor, 1 against, 2 absent.
Thank you, Mr. Rivera. So the next case on the calendar at 73 Washington, involving 73 Washington LLC, is being tabled for a later date. And so we conclude the meeting. This is the conclusion of our April 20th. Yes?
1 second, please.
Sure.
I'd like to just discuss briefly, I believe all the board members received a letter from a group calling themselves the New York City Loft Tenants. I'm just curious how we're going to respond to that letter. We are going to respond to their request. And look forward to your response. Can you reach that?
So in summary, this letter was sent to the board members, and also is it the same letter sent to the bar commissioner, Ira Butler?
No.
Can I see a copy of the letter?
It was sent to the public advocate, the Manhattan Borough President, and council member letter.
Council member letter?
Do you think it is proper to read this letter to the Madam President?
So, I mean, if board members want to talk about it, we can talk about it.
Well, my question simply is, as a board member, how are you planning on drafting a response? Or are you responding?
Well, you don't have to respond if you don't want to.
My only point is that with the public here, perhaps they don't know quite what this letter is about, so I think we should at least read the last sentence so they have some sense of what this letter is about. Or the law court meets in 2 sessions, the private session, public session. It's public session. And the group, either Sussman or Governor, Guy Lester, and Troy wrote to the city, the advocate, borough president, and Councilman Levin is here. We strongly urge you to keep the entire law court meeting process open to the public. We look forward to your response and can be reached at, and there's an email site. So the discussion is whether or not we want to discuss or not discuss or make some remark about the private session which we met today at 1:30 and the public one which we're our witness in now at 2:30.
Well, go ahead.
No, I think I interrupted. That's
No,
fine.
I was just going to say, I think for the record, I don't, the way I read this is a group calling themselves New York City Loft Tenants has taken the time to write to the loft board and CC several city officials, and I think they deserve some sort of a response. Now, how that response is worded, I leave it to your professionalism, but I'd just like to know.
Okay, so does the board want the staff to prepare a response to this? And if so, then we need some suggested response that would be sent to us and prepare and respond on behalf of the board if you want.
have some ideas if that's what we want to do.
Well, I don't see how you can't respond. I mean, we're here for the benefit of the public, for the city of New York. How can we not respond? I mean, it's not a private, yeah, so I'm saying I would like to hear your suggestion.
Well, one is that the private session is lawfully authorized by the statute, and there are good public policy reasons behind the statute. And we can talk about those in the letter, and it's specifically geared towards the process by which the opinion in specific cases are reached. And frankly, there's really no lack of transparency to be invited because the rationale of the board is stated in a written opinion. And that written opinion is subject to appeal into the court system. So, I mean, I'm not sure what the public has lost by virtue of the private session. And I think the private session is healthy in that it affords board members to offer their opinions in a more frank manner than they would otherwise be able to do in public. So those are my thoughts as to what the response might look like. I know others have other.
Well, my concern is just that they give a response. So I'm very satisfied with this response. I think it's based on sound legal judgment.
So is the vote, I know we didn't vote, but is there a motion then to vote on staff preparing a response to this New York City law, correct? Then we'll take your comments all together and we'll respond.
I make a motion that we task the executive director and the chairperson in responding to this letter from New York City Law.
Is there a second? Mr. Carr. Thank you. Mr. Rivera. Yes.
Now we have a motion, can I ask a question?
Sure.
Is the intent that the vote is to have the staff respond for the staff to prepare a draft for our consideration leading to a response?
No, the staff will respond to this letter based on the comments provided through the board members.
Oh, well then, in that case, I'd like to provide a couple of comments.
Absolutely.
I don't know where you see it in the statute. As I said when we started this procedure, which I still think is wrong in January, yes, I think under the public meetings law, that carves out an exception for quasi-judicial functions to be done in private, that if the board wants to, it probably could, once it changes its rule number 1, which doesn't really reference the public meeting law. It says that it spells out the meetings are going to be held in public. And they've been held that way, and the discussion on cases has been public for 30 plus years. So yes, I think probably the board could make this new approach permanent. But whether or not it's a good idea, I think is a different matter altogether. So we can certainly make it clear in some manner, shape, or form that the board is not unanimous in its enthusiasm for this recent change to the way the board is acting.
I'm sorry I cut anybody short, but did anyone else have any other comments? You can certainly email individually to Ms. Balsam if you have if you have any suggested language or something to put in. That's fine too. We'll consider it all when we make a response. But initially, the staff was not going to respond on its own. That was the decision before. So thank you. We need to vote.
Mr. Hubbard?
Sorry, what are we voting on?
You're voting on the staff responding, making an official response to this letter to the New York City law tenants. and incorporating comments from the board members.
Thank you, yes.
Okay. Mr. Barrett?
Yes.
Mr. Bush?
Yes.
Mr. Hernandez?
Yes.
Mr. Delay?
Yes.
Ms. Shelton?
Yes.
Chairperson Hudson?
Yeah,
7 in favor, 2 absent.
thank you, Mr. Rivera. So let's start conclusion all over again. This concludes our April 20th, 2017 Lock Board meeting. Our next public meeting will be held right here at 280 Broadway, third floor conference room on May 18th, 2017. Board members, please don't forget to sign and have your attendance sheet signed. Thank you. Who's got